got an old friend in the studio tonight, Dan McGrath with the Minnesota Voters Alliance. Long storied relationship with you guys. And in fact, an extension of that established relationship is why you're in here tonight to talk about follow-up from an issue that goes back all the way to when we were doing Tea Party stuff way back in the day, and even before that.
Way back, yeah. This stems back to the 2008 election, which is around the time that you and I met.
That's right.
Yeah.
Closing argument.
After.
Yeah. Twin Cities News Talk, AM 1130, 103.5 FM, streaming at TwinCitiesNewsTalk.com and your iHeartRadio app. We are here 8 to 10 weeknights. Appreciate you joining us. You can be part of the program, 651-989-5855. Brianne producing the show, taking your calls. So bring us up to speed. You know, there's a past, present, and potential future here in terms of the issue that we're talking about tonight, which is a request that the Minnesota Voters Alliance has put on, or a lawsuit, not a request.
Started as a request.
Now
it's become a little bit more aggressive of a request.
In terms of trying to get certain information from the Secretary of State. So give us a briefing on where we are up to this date, and then we'll get into where things are at right now.
Okay. Well, we made a request for public information on voters in the statewide voter registration system who had voted in the last couple of elections. And we wanted everything that's included on the public information list that anyone can now buy for $46, plus a couple of elements that aren't routinely provided on the public information list. And that includes whether somebody is marked as challenged because they failed one or more of the eligibility tests, the reason for the challenge. I think that's the only additional piece of information we actually asked for, whether they're challenged and what the reason for the challenge was. We were denied that additional information. Oh, and of course, we wanted voters who had been removed from the voter rolls because they were found to be either dead or ineligible.
Right.
So that's not routinely included in the public information list. We were denied that. The law is pretty clear that all data that's not specifically classified as private by the government is considered public under our Data Practices Act. So we sued when we were denied this reasonable request, which, by the way, they used to routinely grant.
Right.
Now, the information that we discovered on felons voting in the 2008 election was from this exact data set.
Right.
So when we asked for it back then, they gave it to us. Mm-hmm. Then they found out what we were going to use it for. They got kind of a black eye, embarrassed the office. Mm-hmm. Then they said, nope, you don't get this data anymore. So we sued. We won. Judge Jennifer Frisch in Ramsey County sided with us, said the law is clear, that we're entitled to this information. She found that the Secretary's argument against giving us the data was nonsensical. Mm-hmm. A 3-judge panel court of appeals has upheld that decision. Mm-hmm. And now Simon still refuses to give us the information. So he's taking it up to the final step of the Minnesota Supreme Court.
And so what's the argument now? Like at this point, he's lost the lawsuit once. It's gone to appeal. Unanimous decision by the appeals court in your favor. His reasoning has been described as nonsensical, which for a sitting Secretary of State seems to be a black eye in and of itself. So,
it's strong language for a high judge to use in an official opinion, published opinion.
Directed at a constitutional officer who's currently sitting in high office. So is the rationale in terms of failing to accede to the request at this point, is he basically just doubling down on the same logic, or has he tried to tweak it at all?
Well, I will say now, Secretary Simon has not really publicly or in any documentation that I know of made his claims himself.
Okay.
The arguments that the Secretary of State's office is putting forward have been through Nathan Hartshorn, who is actually with the Attorney General's office, who's representing the Secretary of State in this.
I got you.
And Hartshorn, I've watched him dance around the courtroom over and over again, makes stuff up. He just, whatever fits the argument of the moment, he runs with it, even if he's contradicting himself down the road.
Right.
So that's what's been happening. The arguments put forth by the office have, as far as I can determine, been concocted by Hartshorn at the Attorney General's office.
It seems, if I'm going to be highly cynical, which I tend to be from time to time, it seems very much as though the Attorney General's office and the Secretary of State's office, each of which are under DFL control,
yes,
that the game they're playing is we don't need to actually have a case that makes any sort of legal or logical sense. We just need to be able to put up something that can keep this process going and cost this private entity that is seeking this data, which is you guys, the Minnesota Voters Alliance, spending their donors' money in legal battles while we rely upon the endless coffers of the taxpayer.
That is essentially how I see it, yes. The Secretary of State's office has, compared to us, what I would describe as limitless resources to fight us. Knowing that they are in the wrong, they can drag this out for years, which they have, and they can put our donors at significant expense. Now, we have finite resources, and we're spending a lot of money just to try to get justice.
It's an extraordinary effort on the behalf of the state to keep information that, as you point out, is public under the law, out of the hands and out of the eyes of the public. I mean, by virtue of the fact that a similar request was granted in the past, stands
without even batting an eye. They were so cooperative, they practically bent over backwards to give me the information that I was looking for back in 2008.
And the law hasn't changed between then and now.
No. If anything, I think the law is even more clear on what is supposed to be public. And this has been settled in the courts over and over now.
It just seems so nakedly partisan. You would think that there would be interest in more mainstream media sources to cover what is happening here and cover it as an abuse. Have you guys had any interest from media sources, or have you gotten any play?
Yes, I mean, there have been some editorials published in a mainstream press that are favorable to our position on this, because they can see, even if their leanings might be more left than ours, they can see how transparently partisan this is. The Secretary of State, in essence, now asserts that he has the authority to disseminate this information to whom he chooses to.
Well,
so
that's nice.
if he's friendly to your cause, he can give you the information. He actually asserts this authority. But if he doesn't like your cause, then he's not going to give it to you, and he doesn't have to. That's his legal argument.
I mean, if you ask me, that's darn near impeachable in terms of, saying that declaring an authority that does not exist under the law that has the effect of keeping from the public information that a member or organization that is private requests.
And keep in mind now, the Secretary of State is the chief election officer. He is ultimately the authority. It reports who won and who lost the elections. He is elected. He is a partisan. His friends are elected. He controls all the data about those elections. And he's saying, you're just going to have to take my word for it, guys. Candidate X won, candidate Y lost. There were no shenanigans. And no, I'm not going to open the book so anyone can verify that.
And it kind of flies in the face, going back to these debates that we've had over the years at various points regarding election integrity and photo voter ID, or whatever the particular manifestation of the argument has been at any given time. The talking point from the DFL has always been, there is no evidence of election fraud. There's
a ton of it.
there's a solution looking for a problem. This is not a big deal. So if you actually believed that as Secretary of State, if you actually believed that as the DFL, what would you be afraid of in terms of allowing your organization or me or a listener or anybody to have access to this information as to who has been challenged at the polls and why, and who's been taken off of the voter rolls since the last time we had an election?
There is no rational and truthful answer to that question. I can give you the answer that they provide, which is that they're protecting voter privacy. But we already discussed the public information CD that anyone can purchase for $46. What are you worried about if you're worried about your privacy? Maybe your address, your telephone number, full legal name, year of birth. You can just buy that information right now. So what is private, whether or not you were challenged and your eligibility to vote? I mean, that is not something that most people are going to be very worried about. Social Security number, I'd be worried about that. Don't give out my full legal name and my Social Security number, and guess what? They won't. They can't. We're not asking for that. It's not legally permissible to give that information to anyone outside the government.
Right.
And we don't want it. That's not what this is about.
Yeah, I mean, the idea that voting, I mean, they're treating voting as if it's
an inherently public act.
That's
Voting
right.
is public.
That's right. You come out of your house, you go to a public location to engage in a action that has a direct effect upon public policy. The whole thing is public from start to finish.
Right. Now, naturally, we all understand that who you vote for is private.
Correct.
The secret ballot protects you from coercion, and it must be that way, and it is impossible for anyone to discern how you voted.
Right.
The ballot is secret.
Right.
But the fact that you voted is public information, always has been, and must be. Transparency in our election process is crucial for confidence in our election outcomes.
Well, and that also, going back to the whole partisan analysis of this, you know, it kind of implies which side has benefited from whatever fraud has taken place, right? Because if a bunch of Republicans were getting elected in various districts because people were voting in spite of the fact that they didn't qualify or weren't eligible, then you better believe we wouldn't have to ask for this information. It would be front and center and probably reported on the front page of every newspaper. But because the beneficiaries of whatever fraud has taken place have been Democrats, it's a hush secret.
You know, I think that's obvious on its face to anyone that really looks at this. But the gaslighting campaign from the government, from the left, from the complicit press has been pretty impressive.
Yeah.
I mean, to a point where I run into people all the time that I will explain what the evidence is of a problem with our system, and they still will deny it because they've heard over and over again there is no problem.
Right.
This is a right-wing conspiracy to invade my privacy somehow and somehow do some harm and suppress me from voting somehow by having this public information that anyone can buy for $46 about where I live.
Right.
It doesn't make sense, but that's what gaslighting does to people. They'll believe nonsensical things.
And so I think the point to hammer home for folks, other than if they want to be a part of solving this problem, being on the right side of this debate, to make sure that they help you guys out, the Minnesota Voters Alliance. And what's your guys' website again?
mnvoters.org.
mnvoters.org.
Always looking for donations and volunteers. This isn't our only project. We have a lot of things in the work. This is just right now. This is heading for the Minnesota Supreme Court, so it's kind of front and center.
So there's that aspect of it, but then also realizing that the ultimate check on the abuse of power that's been articulated this segment is at the ballot box. It's electoral. We need someone other than Steve Simon, and quite frankly, someone other than a DFL member in that Secretary of State's office, in the Attorney General's office, all of these constitutional offices below the governor that have been DFL for 40, 50 years. They need to be taken back because these people have no sense of shame. They have such confidence that they will never be held accountable, and they're behaving accordingly.
Yes, very much so. Now, we did have a Republican Secretary of State not too long ago. Two secretaries back.
My own very senator. I apologize to Mary Kiffmeyer.
Mary Kiffmeyer, who is still a champion for election integrity now that she's in the Senate. But the Attorney General's office, I don't think, has been held by a Republican in my lifetime. Yeah. At least not to my recollection.
Yeah.
It doesn't matter what your party is. What we need in the Secretary of State's office is somebody with integrity, someone who believes in transparency and actually conducts the job with impartiality, because that's the person in charge of our elections. We have to trust the outcome. That's what prevents us from degenerating into things like bloody revolution. Right. We have confidence in the outcome of our election process, so we believe that our voice matters. If we don't have that, we don't have anything. We don't have a republic. Yeah. It's very dangerous. So we need to trust the process. That's why it has to be transparent.
Dan McGrath with the Minnesota Voters Alliance. My name's Walter Hudson. Closing argument, Twin Cities News Talk, AM 1130, 103.5 FM, Twin Cities News Talk. Dan McGrath from the Minnesota Voters Alliance in studio with us. My name's Walter Hudson. Closing argument, Twin Cities News Talk, AM 1130, 103.5 FM. You can join us at 651-989-5855. We've been talking about a lawsuit that the Minnesota Voters Alliance has been engaged in challenging the Secretary of State, who has repeatedly refused to follow the law and allowed them access to publicly available information, or information that's supposed to be publicly available. regarding our elections, and in particular, they are looking for voter rolls that include those who were challenged at the polls, the reason for why they were challenged at the polls, and also those who were removed or should have been removed from the roll since the last time an election occurred. The Secretary of State has stubbornly refused to provide that information. He's been ruled against by not one, but two rulings. The second at an appeals court that had three judges that all agreed that he was spewing nonsense, as they actually use the word nonsense in terms of describing the legal premise that the Attorney General's office was putting forward on behalf of the Secretary of State. And yet, even now, they continue to defy the law and are forcing the Minnesota Voters Alliance to spend their donor money in order to continue to defend their position, and also tapping an endless supply of taxpayer dollars to keep their side of the argument going. All of which raises the question, is it enough to look at such defiance of the law and waste of taxpayer money and an unwillingness to be transparent and allow access to public information under the law? Is it enough for us to say, well, we just need to elect another Secretary of State, or we just need to elect another Attorney General, and that'll solve the problem? Should there be personal consequences for Steve Simon, the Secretary of State, for refusing to follow the law? That's a question I'm going to throw right at Dan McGrath.
Well, I would characterize what he's doing as malfeasance. Secretary of State's position is a 4-year elected position. His responsibility is to the people of Minnesota to maintain and disseminate records. That's his job. Maintain the records and disseminate them on request. The Data Practices Act says he has to provide public information to the public. He can charge a reasonable fee for copies. Fine. But he can't just drag his feet for 4 years and prevent the public getting access to information about whether our elections are on the up and up or not. This is important. So I believe that there needs to be some kind of a personal price to be paid by this, as our attorney would characterize the Secretary of State, serial violator of the law. It's not enough to unelect him. It's not enough that we can potentially get our court costs reimbursed after we win this case over and over and over again. It's not enough, because the Secretary of State is violating the law. Where is the personal accountability for the Secretary? I believe that there should be a penalty personally upon the Secretary of State when he's willingly violating the law for personal gain, for electoral gain, and for the gain of his fellow partisans.
Yeah, I imagine that in order for that type of a personal price to be paid, there would have to be some sort of legislative framework that does not currently exist.
Probably. Probably. But that's what I'm proposing there should be. Perhaps there's a criminal penalty that could be applied in this kind of situation. It would perhaps be difficult to prove intent, because he would always say that, well, he's acting with his understanding of the law. You know, how do you prove that he didn't know he was in the wrong? But I mean, there's some bar that you have to set. And
I can also anticipate some executive privilege style arguments of, you know, how can you expect a Secretary of State to do their job if they're worried about whether or not they're going to go to jail for acting in their own judgment and what have you. However, you know, when you think about what would happen to you or I or any other private citizen who is in a similar situation under the law, where, you know, you were failing to meet an obligation that you were required to under contract, or you had broken the criminal law in some manner, and time again the courts had said you need to pay this price, and you just kept telling them nope, I'm not going to do it. Eventually you're going to jail, right? Like, at some point it's contempt of court to not follow
eventually. Now, to be fair, there is still a legal process going on. There is this avenue of appeal. But I mean, it becomes very frustrating to go through these appeals when it is obvious, it is clear that the Secretary of State is only going through this process of appeals to impede us, to drag out the process. As you say, the courts described his argument as nonsensical. 4 judges have weighed in our favor in this case. The law is clear. So the frustrating part is that the people should have access to this information yesterday. and we're waiting years to get it.
Now, you are not a lawyer, and neither am I, but you've been very close to these proceedings, and so I feel comfortable asking you this question. If the Minnesota Supreme Court, which is where this case is about to land, their ruling, because it's involving the Secretary of State and a state issue, that's it, right? Like, this isn't going to go to the federal Supreme Court.
It could,
Okay.
but it is such an outside chance of any kind of success that I find it very unlikely they would try to find a federal route to get an injunction on a state court order. It would be almost impossible. Almost.
Right, which never put it
anything can happen with courts.
Yeah.
And you're always rolling the dice, I believe, when you're going into court. Even if you've got the most convincing winning case, things happen weirdly sometimes. But no. If the Minnesota Supreme Court weighs in the way I expect they will and upholds the law, and the Secretary continues to defy the Supreme Court, then he would be in contempt.
Dan McGrath with Minnesota Voters Alliance in studio. My name's Walter Hudson, 651-989-5855, Twin Cities News Talk, AM 1130. So on the one hand, we have this system that is questionable in terms of its integrity. I'm talking about our election system here in the state of Minnesota. And, we may get into reviewing some of the evidence that indicates there are big problems with the integrity of our election system. We've got that on the one side. And on the other side of the spectrum, we also have this continuous effort to expand access to the voter rolls and to voting as such. Voter registration drives, voter registration automatically through your driver's license, whatever their scheme is. We're going to automatically make high school graduates or kids who turn 18 become registered to vote. There's a whole variety of things that have been suggested to try to make sure that they can expand the rolls, coupled with the lack of security that currently exists in the system. And one such method that's being utilized by city ordinance in the city of Minneapolis is involving roping in landlords into becoming de facto voter registration coordinators. 651-989-5855. Closing argument. My name's Walter Hudson. Twin Cities News Talk, AM 1130, 103.5 FM, streaming at TwinCitiesNewsTalk.com and your iHeartRadio app. Brianne taking your calls and producing the show. We've got Dan McGrath in studio from the Minnesota Voters Alliance. Tell me this again. How does this work in Minneapolis?
Well, as you well know, traditionally it is the role of nonpartisan nonprofits to go out and do voter identification efforts, voter registration drives. The League of Women Voters does it. I mean, the political parties do it as well, but a lot of times it's the non-affiliated nonprofits that will go out and do this kind of work for voter registration drives. And it costs a lot of money. It takes a lot of time. A lot of volunteers are required. So Minneapolis decided that they're just going to force the landlords to become their cat's paw in going out and doing voter registration drives.
Right.
So a new ordinance in Minneapolis will require landlords to provide voter registration information applications to their tenants. So anyone that's renting an apartment or whatever, they're going to be getting these voter registration cards from their landlord as part of their lease package, I guess. Landlords aren't happy about it. It's more regulation on them, more responsibility on them. They'll be fined if they don't comply with this. If they forget to go down to the clerk's office and pick up some more voter registrations, they get in trouble. So we're suing to stop implementation of this unconstitutional ordinance.
Now, you've already stated a couple of the reasons why you would oppose this and why the landlords themselves would oppose this. But let me just ask the devil's advocate question. What's wrong with enabling people to get registered, if they so choose, when they sign up for a lease in an apartment? Isn't this a public service that we ought to encourage in the city of Minneapolis?
Registering to vote is a good idea if you're eligible. Everybody should do it. They should take responsibility to do that. People that want to volunteer to go out and do the work, this is work, registering people to vote. I encourage them to do that. It's worthwhile work. But landlords should not be required to become volunteers in these voter registration drives.
Right.
It's not part of their bailiwick.
Yeah, I mean, one of the things that occurs to me is that what you're saying is that as a as a cost of admission to being a landlord and to being in that business, that space, you now have to participate in a political process that you may not sanction, like as an individual.
Yeah, so it's a violation of their First Amendment rights by compelling speech on their part.
Right.
And it has nothing to do with the safety of the tenant.
Correct.
It has nothing to do with the building being up to code, normal landlord things that the city could have an interest in.
Sure.
Public safety. Those are reasonable expectations. The landlord's got to install some smoke detectors and things like that in the building. But providing that, ensuring that their tenants are active voters, that level of activism is not required by city licensing.
I can anticipate because this sounds very similar to, and I listed a number of other potential schemes that have been put forward to try to expand voter rolls. But the logic for it, I can anticipate being very similar to saying that, in service of our community, in service of our democracy, that's probably the type of rhetoric that they would employ.
If the city wants to register more people to vote, the city can mail voter registrations to people that move. They can do that. They can take that expense upon themselves.
Right.
They should not be compelling private business owners to do this.
Yeah.
Now, let me just touch on these voter registration schemes that you're talking about. It's interesting that when a person registers to vote, they're taking responsibility. They're signing an oath,
right,
acknowledging that they know under penalty of law they're eligible to vote.
Correct.
But when you take that responsibility away from the individual voter and you make voter registration automatic, then they can just, anyone that's fraudulently winds up registered to vote can just be attributed to error.
Correct.
Right? Oh, the clerk made a mistake, didn't realize that person was convicted of a felony, because nobody's signing anything saying that I acknowledge under penalty of law,
right,
I affirm that I'm eligible to vote. That's removed from the process when you do that.
Yeah, I can't think of any other example where by crossing a certain line, like turning 18 or graduating from high school, or whatever the case may be, you automatically become a party to an agreement, which is basically what a voter registration is.
Yes.
It's like signing a contract. So you never take the action, you never consider the terms, you never read anything, you're just automatically registered and have the rights, privileges, and responsibilities that go along with being a registered voter without ever having consented to it. Because again, maybe you don't want that, right? Like maybe you don't want your name, going back to the privacy argument. This is an actual privacy argument, as opposed to Steve Simon manufacturing privacy concerns out of public information that comes from people who volunteered to register and engage in the political process. You could make the case, I think, with a high degree of merit, that it is a legitimate privacy concern to become on the voter rolls and to have your address and other information as part of that document without your consent.
Yes, I agree.
So let's review some of the background information, because as has been previously stated earlier in the program, in your work, not just with the Minnesota Voters Alliance, but back when you were working with Minnesota Majority coming out of 2008 and 2012. You did yeoman's work when it comes to examining the voter rolls and finding evidence of fraud and vulnerabilities in our election system. To remind us, and to perhaps for people who just started paying attention to politics in recent years, give us kind of the rundown of what you guys found in terms of data coming out of the 2008 election.
It's really weird. Well, look back where we got started in politics in the state. You and I both entered the fray pretty close to the same time, and where it's taken us.
Right. Yeah.
I had no idea back then in 2008 that I was going to become a champion for election integrity.
Sure.
I didn't set out to do this. We were using the public information CD from the Secretary of State's office to do polls. We were making phone calls to poll voters on the issues so that Minnesota Majority could determine what are the majority positions on the issues and champion those that had a conservative outcome.
That makes logical sense.
Right? That's the name of the organization it comes from.
Sure.
We were champions for conservative causes that had majority support. And that's what we were using the list for. Our volunteers kept coming up to me, though, and saying, well, this is weird. This guy, according to the voter rolls, is 120 years old. Or I called the number and they said that this guy died 10 years ago, but it says here that he voted last year. We're getting all this from the volunteers, and we had so much of it happening that we stopped going, well, that's a weird anomaly, and went, wait a minute, something's wrong with the voter rolls.
Right.
So after that election in 2008, we dug in deep. Well, before the election, actually. We started some preliminary research before the election, found some serious flaws in the voter rolls, brought it to then Secretary of State Mark Ritchie to say, we got an important election coming up. We need to make sure our voter rolls are on the up and up before this election happens. And Ritchie, instead of looking into it, just had a press conference to assure the press and us that we had the best election system in the country. There's nothing to see here, folks. Move along. This election's going to go swimmingly. But then Coleman Franken happened immediately after that.
Right.
And it was a nightmare for months, not even knowing who our senator was, after an election decided by 712 votes, flipped 1,000 votes the other way, and became 312 vote margin of victory for Franken.
Right.
The 60th vote needed to overcome the filibuster and pass Obamacare. That was momentous. That election was so important, and it was such a mess. Well, afterwards, we found out that over 1,000 ineligible felons voted in that election. That's triple the margin of victory that was ultimately ascribed to Al Franken. That's just one example. That was concrete evidence of a problem with the election system. Concrete, proven evidence that led to convictions. People went to jail for voting while they were ineligible, not because the authorities caught them, but because we did with our independent research.
You know, after all these years, I never knew that it started as an effort to poll voters. So that's an interesting bit of context that you guys didn't go out looking to stir up trouble. You just tripped upon, by virtue of the fact that you're using the information for a purpose that was unrelated to elections. You discovered what should have been evident to the people whose job it is to secure our election system.
Right. We found it by accident.
Right.
And it was glaringly obvious to us the first time ever using this list. And people have been using this list for generations. You'd think that somebody might have noticed these anomalies. But when we dug in deeper, we kept finding more and more and more. Like, there were 40,000 more votes cast in the 2008 election than there were voters on the voter roll, public information disc anyways, to account for those votes being cast.
I mean, how can you face that statistic and deny that there was fraud taking place? Fraud is the only answer for that number. I mean, it's not possible to have more votes cast than there are voter rolls unless a certain number of them were fraudulent.
Well, keep in mind that the public information list is redacted. You don't get the full list of everybody that voted, because if they became ineligible to vote, they're removed from the voter rolls. Or if it's discovered after they voted that they were in fact ineligible, they're removed from the voter rolls. So the public information list, anyways, they're removed from the public CD.
Gotcha.
Somebody's found to not exist, address doesn't exist, they come off. If they're mailed a PVC card and the PVC card comes back as undeliverable twice, they're removed from that public list. So there's reasons, but 40,000 of them? 40,000 was significant. The Secretary of State acknowledged the problem at the time and said that they were working on that discrepancy, and their goal was to get the number down to 1,000. So their goal was to reconcile enough of the missing voters that there would still be 1,000 more ballots than voters to account for them. That's a lot.
Well, and that's one way to look at it. What struck me about that statement is you said 48,000 was the number?
It was about 40,000 more
40,000
ballots counted than voters to account for them.
Even to meet their goal, you would have to bring it down. You would have to reconcile 39,000. That work hasn't been done.
It was never done. They tried to say that the discrepancy was because voters that participate in the Safe at Home program were not included on the public CD. And certain overseas absentee ballot types, like the military, were not included in the public CD. So we said, well, okay, how many people are participating in the Safe at Home program? So about 100. Really? So 100 Safe at Home voters, 39,000 missing voters. Okay, well, we're getting there. We put a little dent in it. How many people participated in that military absentee ballot program where it's federal only and it doesn't go on the public information CD? And like, about 1,000. Oh, okay. So now 37,900
Right.
is left to account for. What about those?
Nothing.
Haven't heard anything more about that other 37,000.
651-989-5855, TwinCitiesNewsTalk.com. Wrapping things up with Dan McGrath of the Minnesota Voters Alliance here on your Monday edition of Closing Argument. My name's Walter Hudson. Twin Cities News Talk, AM 1130, 1035 FM, 651-989-5855. If you are quick on the draw, you might be able to squeeze in a comment. We've been talking about election integrity, the Secretary of State, a wide variety of issues surrounding elections and voting. And I just want to kind of touch upon a couple of things that, at the height of the Tea Party, there was kind of this peak energy around elections and election integrity issues, and certain aspects of our election system here in Minnesota came to light that are astounding when you first hear them. Like, for instance, if you were to walk up to a person on the street and ask them, in Minnesota, can you take a busload of, I can't remember if it's 12 or 15 people. I think it's 15.
It was 15. We got that changed. We got it knocked down to 7.
Okay. All right. So at the time, though, back in the day, 15 people, you could take a busload of 15 people, drive them to your polling place, and you individually can vouch for all 15 of them and say, oh, yeah, they live here. Yeah, sure, they live here. And get 16 votes out of your one.
Yes.
Is that true or false? Most people be like, there's no way that's true.
It's very true, and it's been exploited in the past by national campaigns. America Coming Together and Organizing for America both exploited this loophole in our vouching system they would have people in the polling place wearing a name tag that said, I'm your designated vouch person. So it was clearly a conspiracy to vouch for people that they did not personally know, which is a felony.
Correct.
But it was on their websites.
Yeah.
Like, this is what we're doing. They're advertising it.
It's a criminal conspiracy.
It is. And it was advertised publicly on their websites. Someone was charged for it in the 2010 election with the Organizing for America campaign, which evolved out of BarackObama.com.
Yeah. Yeah, it's absolutely astounding. And as you put it, by virtue of the fact that you have to put a name tag on, you don't need a name tag. You don't need to hold.
If you know your neighbor.
Yeah. If you're picking up somebody at the airport and you know who they are, you don't need to hold a sign in front of the vehicle that you're picking them up in because they recognize your face.
I would know something about that too as my part-time gig. I hold those signs at the airport sometimes.
There you go. Yeah. So that's just one of the things, and it's been so long that I can't recall some of the other glaring aspects of our election system that are equally as astounding. But I know you were deeply involved with it. Aside from the vouching, what were some of the other glaring vulnerabilities in our election system?
There's a really, really big problem where vulnerable adults are being exploited for purposes of fraudulent votes in our group homes and our nursing homes. You may recall the name James Steen.
Yep.
It was a group home out of Brainerd where they were busing in people who were court-ordered not to vote because they were mentally incompetent, were being brought to the polling places by their caregivers. Well, to the polling place, to the city clerk's office anyways, to do in-person absentee voting ahead of the elections. And when this was caught by an astute election poll challenger, charges were brought, investigations ensued, but nothing has been done to change the law to protect these vulnerable people from this kind of exploitation.
Consider the insidious nature of that, to take advantage of somebody who is in such a state and utilize them as a tool for defrauding your neighbors out of their...
It's despicable, but some people will do anything for the money and power that comes with elected office.
Sounds like a great place to leave it. Dan McGrath, Minnesota Voters Alliance, TwinCitiesNewsTalk.com.